Hi, I'm Suzanne, the Study Coach. This is the third part of our short micro lecture series. In part one, we looked at case analysis, an introduction, and the importance of case analysis. In the second part, we looked at the importance of how you read your case papers to help you with your case analysis. And in this third short part, we're going to look at how you would approach case analysis in certain legal topics. So for our first topic, we're going to look at the law of contract. Now, clearly, having read your papers, you've identified that the core issue is a contract dispute. So what you're going to do is take a logical approach going through the law of contract to make sure that every step of the way you're able to establish that that facet of the law of contract has been established. So the first thing you're going to do is say to yourself, is there a contract? Yes, okay, if there's a contract, let me try and work out all the essential elements of a contract. First of all, did the parties have a written or oral contract? When did the parties meet? What did they agree? What are the terms? Was there any consideration? Was there an intention to create legal relations? And if all of these things are ticked off and you're satisfied there's a contract, great. You have to look at the witness statements and the documents and the evidence that you've been given to try and work out the contract, the terms of the contract, and then you're going to look at the elements of breach. So who is alleged to have breached the contract? Did the other party comply with any of their obligations prior to the breach? If not, that's going to be an issue. And if there is a breach, is it a fundamental breach of the contract, or is it just a minor breach of the contract? And therefore, what's the remedy? All of these things you're going to go through as you read the papers. And remember that when you look at your case papers, your client and the other evidence that you read may not be in formal legal language. So your client in their witness statement is not necessarily going to talk about the contract between him or her and his opponent. They may simply talk about the agreement, our understanding, we spoke on the telephone and this is what we discussed. So they won't use the formal language of a contract, possibly. So you, as the lawyer, have to make sure that you bring that interpretation to what you have seen and read about the facts. Two people having a conversation where all the elements of a contract have been complied with. You know, as a lawyer, that amounts to a contract. An oral contract that took place over the telephone on a specific day where they agreed X, Y, Z. From your knowledge of law, you're going to say, is this a sort of relationship between two parties that normally gives rise to a duty of care and negligence? And, you know, if it's fairly obvious, you don't need loads of case law. So a pupil and a teacher, well-established duty of care. One driver to another driver on the highway, well-established principle of a duty of care that two drivers owe each other. Okay, so having established that there's a duty of care, the next point that you're going to look at is what is the standard of care that's required under the tort of negligence? And that changes and is different depending on the circumstances. But from the information that you read, you're going to try to put forward an argument for a particular standard of care. Then you're going to look at whether that standard has been breached. What did one party do that fell below the standard of care that one would reasonably expect in these circumstances? And if the bar is here and they've fallen, fine. But if they're here, then there's no breach of that duty of care. You as the lawyer have to work that out. Now, having established that there's a breach, you then go on to see whether any loss or damage was caused by that breach of duty, and then to try and quantify it. So you see that there are certain steps that we go through quite logically to try and establish whether there's a claim in negligence or a defence to a claim in negligence, depending on who you're instructed to act for. First of all, we want to know, when did the statute come into force, make sure it applies. Statutes are great because they usually set out the parties to which they apply, so you make sure that both parties come within that statute. They also usually define the duty that one party owes the other, so you make sure that you find the section that deals with the statutory duty that's imposed on one party to another party, and you've got that as a benchmark. And statutory laws or regulations often deal with what happens when there's been a breach of that statute. And in schedules, they might tell you what you can take into account to consider whether there's been a breach in that statute. And if there's a breach, the statute will also say what the sanction is, whether there's any civil liability or it's just simply a criminal penalty for a breach. So if you're dealing with a case in civil, you want it to say there's some civil liability. In criminal law, then a criminal penalty may be sufficient. So a very, very logical approach that you need to take. And I hope that just by understanding this very short micro lecture series on case analysis, you understand how important it is to get case analysis right. And you will read your papers. You're not going to guess. You're not going to sit on the fence. You're going to come to a rational, logical decision about how you're going to complete the task, how you're going to advise your client. And it will be because you've used that process of case analysis to get you to that point. Anyway, that's the end of my very short session on case analysis. I hope you find it useful. Please subscribe to the channel if you like the video. And if you have a question about preparation for the bar training course, then pop me a line on LinkedIn or email me, and I'll try to do my best to answer it. If I get a lot of questions on the same topic, then I'll do a little mini video series for you to answer the question. Anyway, my name is Suzanne, the study coach, and it's been nice talking to you. Bye.